need you to give me a yes or no. And trying to force her down on something, which I think 100%, it depends on what he says, is good. And I thought that was improper for him to do, because he left the impression that if you respect the police but don't trust them, you're wrong. But it's okay for you to say a police officer is a trained observer, and that's fine, and never try to say, well, you're putting her up at a higher level. So when you got these baby prosecutors and defense attorneys down there in misdemeanor, and these judges are doing it, what do you expect us to do? Object first and say improper? Mm-hmm.
This is a thing. Judges are like us. They are making the best judgment they can based on what they have to work with. When judges don't know, it's lawyers' responsibility to help them understand. The story of the 6 and the 9. The policeman said that he found in the back seat of the police car, under the seat, drugs. That this man, my client, was the only person in his police car that evening. That before he put him in the car, he searched him and he didn't find anything. So he must have taken it out of his butt crack while he was handcuffed in the back seat and slid it under the seat, because he was getting ready to let him go, but he searched his car first. Now, the policeman believed that. The defendant, who wasn't going to testify, said he didn't do that. Artfully, you have to think. People can be mistaken. If you leave it to a police officer to be a liar all the time, you ain't going to win that battle. Question is, can a policeman be mistaken? All right? The shoe thing. The policeman searched the car before the man got in it. There was nothing in it. The policeman searched the car before he started his shift. There was nothing in it. The policeman always searches his car after his shift, even though there was no one in it. What happens if the policeman finds something in the car that he didn't find the first time? An honest policeman will say, I must have missed it. And that's reasonable doubt. And especially when the contraband was checked for DNA. And of course, you couldn't tell. And the policeman truthfully testified at the time that he found the drugs, he didn't smell them. And so it was too late now, and he wouldn't smell it anyway. So you've got to help, all right? You got to help. You have in your war chest all sorts of things that are honestly the truth, that people can be mistaken. And if you don't browbeat the police officer, he may like you and answer truthfully. It's a very simple thing. We have to, and the judge has to have confidence that you aren't going to pull the wool over their eye. You're going to have to smile when you say, Judge, now you know.
Any other questions? We have another question.
I have noticed that colleagues and I and prosecutors have no compunction about talking about gender, particularly in sexual assault cases. I want women, I don't want women. It's like we don't even consider it, and clearly it's subject to Batson. What is y'all's experience with Batson challenges or seeing them based on gender?
I don't think people know. I don't think people have any idea that gender is a reason. Gender works like it's been extended to gender. Batson's been extended to gender. I don't think most attorneys know, and I think because of the way attorneys are trained in criminal, I don't think they're aware of it. I think most attorneys just they're just not thinking that way. And quite frankly, if you do think about it, in the big scheme of things, at least in felony court, there's very few females that go to trial in felony court. I don't know if I've tried one. I don't know if I've tried one in 4 years. Maybe one or two that I don't remember. So that's probably part of it. I just don't think that people's brains are flipped to that.
So you mean there have been very many women defendants that go to trial, Judge?
Yes, that's what I meant, yeah.
Okay.
There was a lady who was charged with 13 sexual assaults. Two young African-American males. She happened to be white. She happened to be from Iowa, and she was a school teacher. And it was certain that the judge was going to give us a fair trial because the judge's attitude is that I don't know anybody who'd tell if they were doing that with their teacher. So that was one attitude. But this lady went to trial, and she was acquitted of all of those things. And it was reported in national news and all of that. What we have to do as lawyers, we have to take ourselves out of the mix, and we have to fulfill our responsibilities to our clients. And as a prosecutor, yours is the state of Texas. I more than once walked up to a prosecutor who gave me a very hard time in trial and said, let me tell you something, because you need to know this. If I had something bad happen to a relative of mine, I want somebody just like you prosecuting whoever I believe that did it. And that's what I think that we don't understand, that there's no bright line and we're not on one side or the other. And most black folk suffer from the hands of black folk. Most brown folks suffer from the hands of brown folk. And you'd be surprised in my 72 years how many black folk don't like me. But they don't count. White either. They don't count.
Any other questions? Any other? Yes, sir.
My name is Oscar. I was noticing when people participate on the voir dire, that when the attorneys ask questions to a person, and then they ask questions, and there are a lot of participants, but some people do not participate for one reason or another. And those people that do not participate, they seldom get stricken. The people that get strike are only the speakers. So isn't sometimes a tactic to let them strike themselves when you don't like them? So if I don't like her, I talk to you and then you speak a lot. That way it's a tactic. It might be a Batson violation.
Well, one of the first things I tell a panel is you don't talk, you don't walk. And I tell them, I say, those of you who end up on this jury, you're going to, how did I end up on this jury? Because you didn't say anything. You didn't give anybody a reason to get rid of you. So, get talking. And that usually, it depends on the type of case too. People are going to be much more chatty about certain types of cases. The murder I had in this, that we just picked on, there's going to be legit self-defense issues. That got people talking. That's different. That's interesting. A lot of people have an opinion on, and this is a cold case, so their duty to retreat is in there, and so that got people talking. Then you get sexual assault cases, and people don't want to talk about it. They just, I think every case is different. A drug case, boy, everybody's talking about drugs. I mean, you can get everybody running their mouth about drug cases, whether how they feel about drugs one way or the other. And we haven't tried many drug cases, but one time it sort of asking the jurors, what do you feel? Just trying to get them, what do you feel about, the war on drugs, is sort of, just getting them talking. And, I've gotten the whole spectrum of people who, hey, I think this is a waste of time, it's a waste of money. My uncle, my brother, he's a felon 6 times over only because he's an addict. And then I've had people who've, typically minorities, who say, look, I live in a neighborhood I know ain't great, and I'm tired of people breaking into my car and breaking into my garage just trying to get a fix. One lady I'll never forget, she told me, it's on the record, she goes, and those guys are pooping in my bushes. And she goes, those crackheads need to be locked up. And that was an older African-American lady. And so, I've just learned, just 10 years working down here, you just don't judge a book by its cover. Whether it's the young guy who said, hey, I got out of that neighborhood and the heck with this guy, or the people who say, you know what, just because I live in a bad neighborhood doesn't mean anybody should get a break. And I think a lot of it, going back to what he just said, you got to let us know what's going on as far as judges. We are not omniscient. We don't know, one, we don't know the cases as well as you do, and we're not sitting there with a strike list like you do on the defense attorneys. We don't, unless you bring it to our attention. It's like PR bonds. Well, you got to ask. Batson, you got to ask. You got to bring it up. And I think that's a lot of it. Just asking, just bringing it up.
Thank you, Judge Patrick. We have another question.
Yeah, it's a question based on something that happened probably before you got here, Judge Patrick.
All right.
When prosecutors will often ask questions that they try and present them as race neutral, but they're really not. For instance, from a scale of 1 to 4, how many of you believe in police officers? And so you ask African Americans, and based on their life experience, they'll say, not very much. And people who are non-African American, whatever, say, oh, I trust them implicitly. They're the best. And so if you raise the Batson challenge, prosecutors say, well, no, it's because they didn't trust police officers. As a judge, there are questions that are just like that that's out there that prosecutors routinely use. They're not race neutral. They're based on actually race, but they're given this other reason. I guess I'm asking, how do you feel about that? Do you see that, for one? And how do you feel about those?
I mean, I'd say most prosecutors ask that question, or some variation of it. I see the punishment rehabilitation more than I see the.
That's the other one.
I don't pay that much attention when they ask those questions because those aren't strikes for cause, so I'm not writing them down. But like I said, in 4 years, no one's ever challenged one of those, so I don't know. For all I know is the ones who are answering in a way that's detrimental to the defense, they've also said 4 other things that they're struck 6 ways to Sunday by both sides. Or, they're answering both extremes and they clearly don't want to be on the jury. Or they're people, that's the only thing that they've said that's given anybody a reason to strike them. I don't know. No one's brought it up. So to say a blanket rule, I don't think that's, I can't answer that.
Well, thank you, Judge. We had 2 more things, at least one more question. And ultimately, I don't know if any of you are aware of it, in the Batson versus Kentucky opinion, one judge wrote that peremptory challenges ought to be abolished, should just be outlawed, that we don't need them, that there should only be challenges for cause. And that was Judge Thurgood Marshall. He was a judge that advocated that it was something that you just couldn't trust peremptory challenges. If a juror was otherwise able to serve on a jury, they should be allowed to serve on a jury if they couldn't be challenged for cause. Somewhat radical, right? But somewhat of an observation of the importance of allowing, or at least disallowing, someone to be struck on the basis of their race or on an impermissible category. How much we needed to protect that particular right. How much he feared what could potentially happen is what that was an illustration of to me. My next question, I had a question. And my question was, there was a 3-step process if we needed to raise a Batson challenge. Because I believe the reason why you haven't seen Batson challenges is because lawyers don't know how to do them. Lawyers just don't know how to raise Batson challenges, and so they don't raise them. But there was something said about a 3-step process. If you were faced with a Batson challenge or had an issue with Batson, there are 3 things you need to do. Can you tell them, Francis? And we'll end with that.
Well, the first step is what we do. We raise a prima facie case that the state has exercised their peremptory strikes in a impermissible manner. Sorry, David. And then step 2 is actually then the state responds and gives their race-neutral reasons. And it basically just becomes, the state may say it was because she answered this on the question, and you could respond to that. And ultimately, it's the trial judge who makes the decision. The decision that's made by the trial judge is no longer a matter of law. It's a question of fact, which is a little bit interesting. And then the other thing to remember is that, the defense, as the ones raising the challenge, we carry the burden to push it through. Once we raise a prima facie case, so actually the judge could say that's not a prima facie case, and the state doesn't have to give a race-neutral reason. If the judge does say...
I have, now that I say this, I had an attorney raise a Batson issue, and he could not even articulate. He was claiming a Batson issue on Hispanic jurors, and the defendant was white. And he could not make any sort of connect. It was almost like someone told him, okay, when you go up there to do strikes, it was a baby defense lawyer, when you go up to make strikes, you need to say this. Yeah, I mean, it was just sort of, it was very awkward, and the attorney had no idea what to say. It didn't go very far.
And I mean, I think that there's a lot about Batson that people just don't know. Like, you can use it for gender, and it is important to remember that the right. Does the race and gender of the defendant matter? No, it doesn't. So you can have a white defendant. You could have a white male defendant, and they could strike a black female panel member, and you can still raise a Batson challenge.
And I don't think attorneys know that. I think attorneys assume the prima facie case because that they say, well, I have an African-American defendant and that was an African-American juror. Well, no, that doesn't matter.
Yeah, because you could have an
They
African
think that's the
yeah.
prima facie case, is that the race is the same. And that doesn't have anything to do with it.
Exactly.
Yeah. Yeah.
So process one, step one of the process is establish the prima facie case, right? And you establish the prima facie case by showing, I'm right near the mic, man, they can pick me up. Yeah. You establish a prima facie case by showing what? Step one, you establish prima facie case.
That the state has exercised their peremptory strikes in an impermissible manner.
Meaning, let's say that you had two people on the jury, one white juror, one black juror. They answered the question exactly the same. The prosecutor strikes the black juror, right? And so you can come in and say, hey, look, judge, this juror has answered these questions the exact same way as these white jurors over here, and they struck this black juror. So that would be enough to establish prima facie case.
You could also even say that they struck all the black jurors who were left after challenges for cause. You could look at the ratio. There's a couple of different ways to show prima facie case. Initially, I think that a lot of them probably don't go through the analysis of they answered the questions this way, because you're looking at the panel, all of a sudden you're like, what happened?
If you're taking good notes, you'll get those questions.
Mm-hmm.
But in any event,
I think it's that you're entitled obviously to a cross section of the community. You're not necessarily entitled to a cross section of the community that's, got the same ratios, and you have challenges for cause that come in. You have all those other issues that come in, and I think that's the hard part. You could have a panel where maybe all of the African American people on the panel were struck for cause. That becomes a little bit harder, but. That's really the hitch. You need to have a cross section of the community